It's been a great day, and I think and hope that this will be a great final session where we try to dig into, take as much as we can, a 360 view of the operation of the DMR process. I'm really happy that we're going to begin with the voice of someone who has had personal experience as a relevant person of the DMR process. And that's Darren Maguire. And I'll briefly introduce Darren, but then I know Laura Dowling, who is a senior advocate for the Greater Dublin region of NAS, of the National Advocacy Service for People with Disabilities. So briefly to introduce Darren, he's a 54-year-old man who suffered a hypoxic brain injury as a result of a drug overdose in 2022. Darren has prepared a piece describing his experience of obtaining a DMRO. So Laura, over to you, please. Thank you very much, Laura.
Hello, hi, my name is Laura Dowling. I'm a senior advocate with the National Advocacy Service, and I'm going to read this account by Darren and his advocate. So Darren's a 54-year-old man. Darren was a professional dancer before his brain injury. On the 20th of April 2022, Darren had a hypoxic brain injury from a cardiac arrest caused by a drug overdose. The National Advocacy Service began to work with Darren in early 2023. At that time, Darren had been advised that an application to make him a ward of court had been lodged by the hospital. Darren was clear from the first meeting with his NAS advocate that this was not his will and preference. Darren recognised that he would need decision supports. However, he was clear that he wanted the person supporting his decision-making to be his sister, Leslie. The NAS advocate supported Darren to write to the court to state that he opposed being made a ward of court and would instead like for a decision-making arrangement under the Assisted Decision-Making Act to be made, with his sister as his decision supporter. At this time, Darren also had to fight to have a do not attempt resuscitation order lifted from his chart that had been put in place when he had entered the hospital in a critical condition. Although Darren was clear in his will and preference to have this lifted, this process was not easy. Through strong self-advocacy and advocacy support, Darren successfully got this DNAR lifted. The NAS advocate supported Darren in his communication with his solicitor through the ADM process. They supported him to write to the court and to attend and speak at his DMR hearing. Darren had been very clear in his will and preference from the beginning of his work with the NAS advocate that he wished for his sister to be his decision supporter. It was suggested by professionals involved that a person from the panel would be a better option for Darren. Darren rejected this. He was clear in his correspondence to the court and when directly speaking to the court that he did not want a person from the panel, he wanted his sister, Leslie. Darren was successful in this outcome and now his sister in the role of decision-making representative. When asked about his experience in the court, Darren says, "Judge O'Connor was a gentleman and listened to me. My sister was a great help, but we needed a professional advocate to really make people listen to me. We couldn't have done this without my advocate." Darren has made huge progress and has asked that we share his ongoing goals as he continues his rehabilitation. Darren now plans and is taking steps to begin visiting young people in schools and groups. Darren's wish is that by sharing his story and letting young people see where his drug taking led him, he may play a role in preventing young people taking drugs and facing similar situations. Darren has said that his road to where he is now has been very difficult, but he is a rich man with the family and support he has had around him. Darren is currently awaiting funding for support staff to assist him to achieve his current dream of going into young people to speak about his experiences, to give his days purpose and meaning. This will be transformative for Darren and is his current drive. What follows now are Darren's direct words in relation to the experience of the DMR process. I'll be very honest with this. I could not believe the help I got and that I continue to get. Pader, the solicitor, has been nothing but positive and has supported me through this so well. It has been so rewarding to work with Peadar. He explained everything to me. I am so grateful. Not everyone gets the opportunity to get back your control, but I did, and that was because of Peadar's help. Peadar and my advocate made sure everything was about me and that I knew what was happening and what the outcome was and what I wanted. Thank you. I can't say enough how grateful I am to have had the support I have. I am a very lucky man in lots of ways.
Thank you very much, Laura and Darren. And I don't know if you're listening, Darren, but we really wish you all the best in achieving your ongoing goals. It's my great pleasure now to invite His Honour Judge Dr. John O'Connor of the Dublin Circuit Court. Those of you who were here last night will have had the pleasure of listening to Judge O'Connor. And I suppose one of the things you will have seen is the absolute commitment which Judge O'Connor shows to the relevant person. For those of you, and Anya mentioned this yesterday, but for those of you who want to get a feel for what kinds of things go on in the court, one couldn't but recommend reading Judge O'Connor's published judgments. There are 2 available on courtservice.ie. They really give you a flavour in very accessible way of the kinds of cases that come. So I'm really happy for Judge O'Connor to talk about what he needs as a judge in order to do his job and be fair to the relevant person. So thank you very much, Judge O'Connor.
Thank you very much, Mary, and incredibly moving presentations today. And I won't dwell too much on that, but just to say that I was really moved by the various presentations. I appreciate time is quite short, so I'll be very quick. I know the bell will ring in any event. Just one thing I think we can absolutely make sure. Is that it? Better? Yeah. One thing we can make sure is that we have dumped nostalgia today. The problem with nostalgia in relation to wardship is that it, like all nostalgia, it gives us some facts which are true, and then it omits other facts. And I think we can move on from that. Just to say that from a judge's point of view, we had a very significant change last year. In 1924, we had the Courts Act, and that appointed judges or outlined what judges were. And it was very ad hoc from that until last year. And I was involved in the Judicial Planning Working Group, which was an interdepartmental group which set out the criteria for new judges. And one of the criteria, of course, is the assist decision-making. And we have got 24 judges last year and another 20 judges this year. We're all very conscious that we take an oath of office and that our function is that we have to uphold the rights of persons who appear before us in all matters. So I just want to pick up on 1 or 2 other things that have been said today. One of the things is that conflicts of interest. That's the judge's job to see if there's conflicts of interest. Now, bear in mind what I said yesterday, that up to 40% of the cases that appear before me are lay litigants. But by and large, they'd go with me in relation to what's involved. Conflicts of interest are pretty clear-cut. If you're involved in somebody, and if you have an interest in the property itself or whatever, you can have a conflict of interest. The other issue I want to talk about, and I know Professor Sean O'Keefe is going to talk about the medical reports or capacity reports. Just to put this into context, people are talking about being worried. I've never seen, and I'm 44 years a lawyer, I have never seen a case in which a doctor has been sued for giving a medical capacity report where it's, or successfully sued. I have seen cases where people have been sued where they haven't given it, where there's been a delay, or where they've winged it. It's a bit like in school. If you wing your project, you're in trouble. The other thing that I talked yesterday, that there are 3 essential proofs that we need in court. One is the capacity report. We're going nowhere without that. It's not a medical report. It's not a status report. I don't need to know what the medication is. What I do need to know is it a functional capacity report? It's not a status report. The second thing that I absolutely need is the voice of the person. Now, Section 139 says the relevant person shall be in court, and that is so important to have that relevant person in court if we can at all. We try and make it as informal as possible. We appreciate that going to court is not easy for people at any stage, so we don't dress in robes. We try and keep it informal, but there is a certain formality to court in any event. We can deal with it online, but it gives me context. You know, I can understand the case much better if I can see the person, but at a very minimum, I must have the voice of the person, largely through an advocate's report, or indeed with the person themselves, either in person or online. And the third thing is that legal representation, and that is really important, and the government have provided legal aid in relation to that, so there's really no excuse not to have the relevant person have legal representation. Apart from that, there's case law. AC versus University Hospital Cork in 2018 made it very clear that a relevant person, even if they lack capacity, also have legal capacity, and they have constitutional rights which must be respected. And you know, it's my honour and privilege to deal with the people who come before me. It's certainly a growth area. In July, in 1 week alone, I did 40 of these applications in 2 days. That shows the numbers that are being coming through, and that's only going to increase as we go forward. The other thing that was mentioned, and Mary mentioned as well, the Circuit Court is a court of statute. So we have to abide by what our statute says. We don't have an inherent jurisdiction as such, and we are very conscious of the Constitution. International agreements such as the United Nations Declaration is important, but it's not directly into Irish law. What brings it into Irish law is the actual act of the Oireachtas, and that's what we have to uphold. We can use it maybe to interpret legislation as such. So I know I'm under time pressure there, but if I can say anything to you in relation to it, is that we have to uphold the independence of the relevant person insofar as we can, and we try and do our best in relation to that, and I'm sure you all will.
Very many thanks, Judge, and happily we will also have Judge O'Connor joining us for our what we're describing as a fireside chat, but there's not much of a fire in evidence. But first, I want to turn to Sean O'Keefe, who I think at this stage needs no introduction. But Sean's going to talk, some of this is a reminder, but talk about the functional test and preparing the documentation that is needed for Part 5 applications and why this is so important. Over to you, Sean.
Thanks, Mary. Thanks very much, and it certainly follows on. Judge O'Connor has mentioned the capacity statement, and this is what's written in the court rules. And I'll just highlight a number of things, the details of any examination or assessment. And it is a functional test of capacity, nothing else. And it is the specific decisions. And these are the important things to remember. Again, the functional test, and here it is, on the basis of their ability at the time the decision is to be made, the nature and consequences in the context of the available choices. So we need to start with the decision and what the choices are that the person faces. Again, a starting presumption, which might be rebutted. Merely making unwise isn't enough. And we need to look at person-specific factors in terms of trying to support them in the best way possible. I'm not going to read this, you're all familiar with it, but it is about setting workable bars or thresholds and being explicit about what they are, so that if you are reporting to the court can see what threshold you set, and they might think it was too low or too high, that's fine, but you need to be clear about what you expect the person to be able to understand. And the general point is you keep it as simple as possible in the context of the circumstances. There's no need for people to become an expert, and it's reasonably foreseeable consequences of the decision. And we mustn't go around holding people whose capacity is in question to a higher standard than those whose capacity is unquestioned. So we shouldn't be moving the bar artificially. Retaining it is long enough to make a decision, so it's not a memory test. And using or weighing is often the hardest one, because people use or weigh information in accordance with their beliefs and values, not in ours. And that means in a healthcare context, they may not advantage safety over all other considerations. They may value independence over safety. We need to be able to elicit those beliefs and values. So the capacity assessment isn't occurring in some sort of vacuum. As a cognitive exercise, you're trying to get the beliefs and values in order to be able to interpret it. So I know it's very important to get the will and preference from Bibiane, Sage and colleagues, but the assessor also needs to remember those guiding principles all the time. We can't be subcontracting it and saying that's for somebody else to consider. The assessor too must be considering will and preference, considering beliefs and values throughout. The fact that we have to cover all 4 elements and report on them, absolutely important, but that doesn't mean it has to be robotic. It's meant to be a conversation between people that elicits these as naturally as possible in a conversation. I belong in the real world of the HSE and hospitals and overcrowding and pressure to discharge, but really important that assessors understand that the responsibility is to the court. They're taking on a personal, professional responsibility to do the best job possible for the court, and that's where the responsibility lies when providing these statements. And they may, in some circumstances, be required to justify the report and their conclusions, and that's not meant to be intimidatory in some way. That's simply what happens if you provide reports for a court. It's not a technical exercise. It's not a tick box exercise. It's a law, and more importantly, it's a human rights law, and the stakes are high. And sometimes the language, I don't think it means it deliberately, but it has a, we'll get a DMR. Well, no, you won't get a DMR. You will submit an application to the court, and the court will decide whether or not that's appropriate. And we have to remember that even if it's justified and appropriate to seek a Part 5 application and a DMRO, the person loses something as a result. And it's never going to be taken lightly, and nor will it. And doing a good assessment doesn't require a vast amount of technical knowledge, of cognitive assessment skills. It does require diligence, and it does require the right attitude and understanding of the important principles. The DSS has very helpful guidance just in general about doing capacity assessments, and it emphasises the fact that particularly if you don't know the person, you need to understand the decision, the context. You need to do some work, basically. So you need to do that preparatory work before you go there. And to be fair to the person, you need to be sure that the person has had the best chance to put the best foot forward. What's the right time of day? To make sure they're not sedated at the time. All of these good principal practices and support needs. If you know the person, you may know some of it, but if you don't know the person, you need to acquire that knowledge. So particularly if you're, the phrase is wrong, but parachuted in as an assessor, you need to get that right. It's disappointing that we've seen high quality reports. We've also seen some terrible reports, let's be frank. And if you're producing sloppy and inadequate and cursory looking reports, then it's a perfectly reasonable conclusion that that probably reflects a sloppy, inadequate, cursory assessment as well. So it's disrespectful to the court to do that kind of work, and it'll be rejected. But it's also disrespectful to the relevant person who's being assessed, and I'd argue it's also unprofessional to do that. We've seen people not doing a functional assessment at all, and that includes sweeping statements or status questions about capacity, and still waiving MSEs and MOCAs and even more sophisticated test scores around. None of this is a proof of capacity under the functional test, so we need to do it right. And again, if you do the functional assessment without adequate details, well then it isn't adequate either. So it's not just a matter of saying can't understand, can't use or weigh, can't retain in that kind of way. You actually do need to be able to persuade the court that you've done a diligent job and you can explain yourself. This is the HSE template, and at least it'll satisfy, it'll tease out the requirements of what's needed for a good quality report by making sure that you don't do it wrong if you actually complete it in the spirit in which it's intended. So there's no point in reinventing the wheel, is what we tell people. It's actually use the template. It's there to help you through the process and to give the best possible report. So it's not a matter of, when I'm saying good faith, it's not a matter of saying how little can I get away with writing and how quickly can I get this done, when you go back to the importance of the assessment for the relevant person. It involves the details of the decision and the assessor and how you did it. And I think recording the person's own words, again, we also have a responsibility to think about the person's will and preference throughout all of this. And reporting the outcome, it's for each specific decision. This is not wardship light, it's all about specificity. And if there is a lack of capacity, the likelihood of recovery, but it's really to be able to say that we've done this rigorously and the assessment is accurate. And that means that the court has the clarity and is able to follow your reasoning in reaching some conclusion. And if there is uncertainty, then be honest about it. And that sometimes occurs, and sometimes it needs more than one assessment or repeated assessment, and so be it. So it's all very much about, excuses wear thin now. We are more than 18 months into it, so it's about time that we got it right. And that's, I feel like I'm haranguing this audience, who are all very good, but it's the message that we really do need to get across to our service in terms of saying, you need to do better, at least some people need to do better, and that's very much our focus of work for the next period of time. Thank you very much for your attention.
Many thanks, Sean. Clear and to the point, as always. So we're going to ask our speakers, for our panellists, for our fireside chat, to make their way towards the stage, please. And that's Judge O'Connor and Sean in the first instance. And I'm not going to reintroduce them. We also have Bibiana Savin. Bibiana is the CEO of Sage Advocacy. I think Sage probably doesn't need an introduction to this audience, but it is perhaps worth reminding ourselves of the tremendous work which Sage does. It's the National Advocacy Service for Older People, and also supports vulnerable adults and healthcare patients in certain situations. Bibiana has a very wide background experience, and you can read about that on our programme. We also have Dr. Joanna Ralston. Dr. Joanna is a practicing barrister at law. She's got 21 years post-qualification experience. She's based in Cork, but at this stage I think she's working in quite a number of circuits. And at this stage I know she's built a considerable practice in respect of the Assisted Decision-Making Capacity Act. And so we're really grateful to have her, because she provides us with a perspective outside of, we'd say, the Dublin area, which we're getting so well from Judge O'Connor. We've got Ultan Hines. Ultan is Head of Service of the HSE Nursing Home Support Scheme. And this scheme supports over 23,000 people each month and has an annual budget of, 1.2 billion euros. And I know and I should say Ultan has over 30 years of public service experience, and I know from many meetings with Ultan how utterly committed he is to ensuring the protection of the voice of the relevant person. Another person who I know from many meetings is so committed to protecting individual rights and rights of the relevant person is Amanda Casey. And we're very lucky that Amanda has recently taken up her role as the first Chief Social Worker for the HSE. She's also Adjunct Assistant Professor of Social Work in University College Dublin, and has a vast experience. And again, everybody we're meeting today has wonderful practical experience, on the ground experience, and I think that's one of the things for which we are very grateful. So just to take you through, have I missed someone? Oh, good God. There's something absolutely appalling about forgetting the Director of the Decision Support Service. I should be shot, and no doubt I will be shot. Anya has been, as you all know, we've heard from her many times over the last couple of days, an absolute stalwart in developing this this regime and bringing it into force. So thank you all very much indeed. Just to give you a flavour of how we're planning to proceed, we've got from now until 3:45 for our so-called fireside chat. So that's me basically asking questions of the panel. These are questions which have been sent in from us, from various people, and so we're going to be asking and working through the panel and asking them to speak to their particular areas of expertise. Thereafter, we will be opening this to the floor and to our colleagues online. And Caoimhe will be telling us what's coming in online there. And any questions you might have for any of us who spoke in session 3 as well as session 4, in other words, on the inherent jurisdiction wardship, we'll be taking those at that time as well. And in order to allow you all to escape the famous Cork traffic snarl, we will be finishing our questions and answers at 4:05 and then handing over to Caoimhe. Great. So thank you all very much. And Joanne, I'm going to go to you first, if I may, for a kind of an overview question. So you've seen quite a lot going on outside of Dublin. How successful, in your view, has the 2015 Act been in practice before the courts in changing perspectives on the rights of people whose capacity is in question?
Thank you, Mary. I suppose it has been successful to some extent, nowhere near where we need to go, but from where we started, hugely successful. And I suppose it's a case of whether one is a lawyer or whether one is acting for the applicant or for someone like the HSE or the judiciary or family members. It does require that change of mindset that this is about the relevant person and looking at it from the perspective of rights. So we've made progress, but we've a good bit way to go. So still room for a lot of improvement.
Wonderful. Thank you. Thank you very much for that, Joanna. We may come back with some further follow-ups on that. So we've come a long way, but we've got a distance still to travel. Amanda, I think it was last night or else early this morning, actually, Sean spoke about the impact, how social work has been bearing a lot of the brunt of the Act. What's your impression of the impact of the Act on social work practice?
Okay, thanks. Oh, this is working, is it? Yeah, okay. So I think maybe there's two bits to it. In theory, social work, we were really excited about the kind of coming of the Act because we would always have felt that the guiding principles were very much aligned to the kind of code of conduct and ethics for social workers. We are a human rights-based profession and we would come at things from a strengths perspective, but I'm very conscious that we can't just sort of rest on our laurels there and we can't become complacent about, I suppose, our role within the Act. I think we have to challenge, I suppose, those kind of preconceived notions around ability, around capacity, around risk-averse practice, and my own favourite, which is what it means to be vulnerable and a vulnerable person. So I think, we often have, I suppose, struggled within social work around that balance between care and control, specifically, I suppose, within, kind of child protection work. And that becomes even more complex, I think, when you're working with adults. So for me, from a practice point of view, it highlights the importance of maybe ongoing clinical supervision and around that ability to reflect, and also the importance of working within interdisciplinary teams and drawing on support from all across the professions. Thanks to Sean for acknowledging the commitment of social workers to, to implementation. And for me, it's about bringing the Act to life. So I think it's really, really important that we kind of continue to do that. I suppose the brunt of it, I think, in the initial stages was and continues to be felt within the acute setting. And I think, unfortunately, we continue to have that over-reliance on the acute setting for making what are often crisis-driven decisions. And I think Joanne mentioned it earlier around urgency being the enemy of good decision-making. And I think we're still in that, so we have an awful lot of work to do to try and kind of move away from that, trying to support someone to self-determine in a hospital when the clock started the minute they hit the trolley in ED. It's just not the right place to be doing that sort of work.
And that identification of that clock ticking and beds and the importance of freeing beds and all of that, in a sense, leads me, Ultan, to talk to you and to ask you a question about the nursing home support scheme and the relationship. I mean, we saw from Judge O'Connor's statistics last night how significant the nursing home support scheme has been in terms of numbers of DMRs. when is it needed? When does a person need to get a DMRO in order to access the nursing home support scheme?
Okay, so thanks, Mary. So I suppose it's, for us in NHSS, there was actually changes to our legislation. So they're explicit changes. They're actually quite clear. You change your controls, and then people have to meet those controls. And I suppose that's where the challenge was. Effectively, by changing the application form, we implemented the requirements. Then people had to meet it. As I say, the secondary bit was the challenge. So the key area where demand has been driven for a DMRO has got to do with applying for ancillary state support, which is the loan. So to put that in context, today 17% of people who are supported under NHSS are in receipt of the loan. So that's probably the maximum number who will ever approach, and many of those people are able to deal with the application themselves. So it's a subset of that 17%. Now, there is a very small number of people who would apply for the 3-year cap on farms and businesses. So this is an extra benefit that if you have a working farm, it's a family farm or family business, you can apply for a 3-year cap on the value of that asset. There's specific requirements around that, but so there has been a very, very small number of those coming through. Interestingly, and just to pick up on a point from Judge O'Connor about people who are very wealthy usually have their affairs in order. We have about 300 applications for farms, and we've had 1 application for family business in 2 years. So that very much tells you who has and hasn't got their affairs in order. And that's all got down to accountants and other experts having things put in place. The other area got to do with if the person does not have the capacity to make the application, a specified person, if there isn't a specified person to act for the state support application, then there will be a need for a DMRO for that as well. But there's provision there for family members and also then for healthcare professionals to step in to do that. So I mean, that's the relatively simple end of the application. The reason specifically for ancillary state support is not to apply for ASS, it's actually to give the HSE authority to put a charge on the property. So ASS is essentially a mortgage, and we put a charge on your property in the same way a bank would on a mortgage. So the DMRO is not so much applying for it as they're giving us permission to put the charge on after we agree that it's possible to do it.
That's brilliant, Ultan, thanks. And there may well be further questions on NHSS because it's been such a significant issue, but we'll come back to those. I'm going to turn to you, Bibiana, and I suppose again linking to Ultan's point, which is the kinds of cases you're seeing in SAGE. So are they nursing home support schemes cases, or what kind of cases are coming to your attention in the tremendous work you do in SAGE?
Yes, just to date, SAGE Advocacy has been involved in 651 cases linked with the decision-making representative order applications. 500 of those cases arose from new referrals altogether, so we were called in specifically to capture the voice of the person and bring that to the attention of the court. And in about 150 cases, the decision-making representative, the need for a DMR arose in casework that was concerning other aspects of the relevant person's life. So primarily, majority of cases we've been focused on the nursing home support scheme application and the loan. As was mentioned earlier, we have had cases around renting a relevant person property, upkeep of the property, or sale of the property. We have had cases where at SAGE there were decisions around medical interventions, hospital admissions, or treatment. We have had cases where a DMR was needed to sign a contract of care for admission in the nursing home and pay the fees for the nursing home care. We have had cases where the management of finances, shares, it was the focus of the application. We have had a small number of cases where there was a request to relinquish the relevant person's right to their own property. So there weren't many, but we had few, and some of the ones linked with donations as well.
Very interesting.
We have had situations where applicants come to us to tell us that they decide to go for a DMR application because the family solicitors did not engage in setting up an EPA at an earlier stage, and the relevant person become unwell and needed that. Or we have such situations where private nursing homes had to close down and the residents were not able to manage the finances around that to stop standing orders and set up new standing orders, and the financial institutions required a DMR and not less intrusive intervention for that purpose.
That's really, really a fascinating, I suppose, picture of the kinds of work which you've been doing, and I suppose just all the things, and just that linkage back to nursing homes and how important, in some senses, they've been in your work, and indeed back to Walton's point there, and that might be something people might have questions about later. Judge O'Connor, if I might turn to you, and this follows on in a sense from the advocacy work of SAGE, and in the sense you've told us this, but I wondered if you might give us just a sentence on. It's clear you make the voice of the relevant person central to your work as a judge. Why is that so important to you in your role in reaching judgments?
Well, I think it's a basic principle of law that you shouldn't make a decision for somebody without them being present. I mean, and to use not a 21st century phrase, but audi altum partem is a basic thing that law students learn on day one. And the idea that we would make decisions without them being involved or even seems just very harsh. But in addition to that, from a judge's point of view, if I can see the person, I can get some sort of context involved. I can understand them a little bit better. I can understand the reports that are coming in. If I don't have that context, it's quite difficult. And sometimes I have conflicting reports. And I'm trying to make sense of that. Also, it gives that person a chance to address me, and they do. Yeah. You know, sometimes they don't, but sometimes they do give me decisions, particularly in relation to will and preferences.
And as we saw from Darren, apparently you're a gentleman, which was very nice that he had something so good to say about you. I'm going to turn to Sean and then Anya, two kind of related questions to the court process. And in a sense, Sean, my one here is about avoiding getting to the court process. Why is it important to think about CDMAs, co-decision-making agreements, before going the DMR route?
But you always have to use the least possible tier of support if needed. And it is complex, and I think the training will help that's going up from the DSS now shortly in getting it. It also goes back to the Part 5 assessments. If you do a good quality report regarding understanding and using or weighing, well, then it's easier for the court to decide that you should treat the person, even if they have nobody, that a DMR should act as to make decisions jointly wherever possible. So it's having it in mind, even if there isn't a person, in order to help the court make that decision. And also, of course, if there is somebody in that position, you shouldn't be anywhere near the circuit court. You should be doing a Part 4 assessment with a view to going to the DSS. So, you know, it is complex. I understand people have to get their head around it, but I think it really needs to be a focus now in the next few months to de-emphasise Part 5 applications all the time when we can get away without them.
Yeah, and I suppose really when you think of it as, I can't remember, somebody has pointed out, you know, co-decision making is such a new concept for us in Ireland. You know, it's taking a bit of time to maybe bed down, and I suppose we can hope that might happen. Anya, if I might turn to you, and obviously you've kind of seen what's coming out of the courts, the decision support services. So when a DMRO was made, it's then making its way to you, Anya. Have you seen any evolution in terms of what you're seeing coming from the courts?
Thanks, Mary. Yeah, a useful opportunity to clarify. We're not in the court for the most part at all, really. And so just a few matters where we've had to be the applicant, where some orders have needed to be varied or discharged. So sometimes the first, and more often than not, the first we know about an application is when the order is sent to us. I know in July, maybe 2023, when the first began to come in, it was quite exciting, but we looked at them and thought, I wonder what that means. And I think there has been a definite improvement. There has been an adoption of template DMROs. I know judges can't be ordered, as I understand it, to utilise the templates, but the orders that we're seeing more recently do a better job of making sure that there is compliance with the Act. Sometimes some of the detail hadn't been attended to in terms of saying whether two DMRs were to act jointly or severally. That happened a bit, but sometimes not a proper link between that finding in relation to capacity and what a DMR was being appointed to do, which should be the least restrictive, most focused kind of approach. So I think we are seeing more applicable, more intelligible DMROs, and there's some things that we can still work on if we're permitted to, with the judiciary, also with the court service, who for the most part draw up these orders, you know, continuous improvement being the object.
Brilliant, thanks a million, Anya, which I think is a nice story to be able to tell that we are seeing improvement, although, as you say, there is space for more. On that theme of improvement, and of an interesting, well, I think is an interesting question here for Joanne, if you don't mind, Joanne. And what it asks is, how efficiently does the court process work? Now, that's asking you a very big question, because I know you work across a lot of circuits. And of course, efficiency isn't always the most important thing. Sometimes justice is important as well. But over to you, Joanne, just give us your impressions.
That is an interesting question. I mean, Dublin is working very well. We're very lucky in Cork as well to have a very efficient court services, you know, a number of judges as well as, you know, very efficient solicitors in the Legal Aid Board to help with the, you know, ascertaining the will and preferences of the relevant person, as well as other advocacy groups like SAGE and the National Advocacy Service. But after that, it's a bit depends on where in the country you are. Like if it's the Southwest or the Western Circuit, you know, there are delays because the dates for the applications when they're being listed are few and far between. So it can take much longer. So unfortunately, it depends on where you are in the country. Like if you're in Dublin or Cork or the Southwest, or Limerick, things are working quite well. Other areas, things are working well, but not as well as they could. And I think the main issue really is the lack of you know, court dates for listings. And I know Judge O'Connor said we're very lucky to have more judges now than we had before. But I suppose there are some issues there that need to be ironed out, such so that no matter where you live in the country, and Mary, you mentioned the word justice, but you know, justice in this arena is about the voice of the relevant person being heard, and you know, to do them justice for their voice to be heard, they shouldn't have to wait effectively too long to have their application listed before the court.
And Joanne, while you have the mic, could I ask you, sort of similar to the question I asked Anya in terms of evolution, we'd say over the kind of 18 months or so that you've been, you know, appearing in these cases, have you seen changes, or what kinds of changes would you say you've seen?
Yeah, there have been changes on a number of fronts. I suppose, firstly, it's becoming more streamlined in terms of how the judiciary are approaching the applications, and there is more consistency there now than there would have been, say, in June, July, October of 2023. So there's a lot more consistency now, and there are effectively more of them singing off the same hymn sheet, having a particular approach, which I'm glad to say is that the relevant person is central. So there's been changes there. The biggest change, I suppose, from the start of the process is that all applications now, you know, for solicitors who would have done applications for applicants back in, you know, June, July last year, and are coming back now with other ones, it's a surprise to some of them to say that, you know, when they're told, well, there has to be independent legal representation here. So that's a must now in every application.
And that's changed.
And that's a huge change as well. So that's every application now, whether people want it or not. I mean, there have been applications where, on behalf of the applicant, people have objected, family members, well, I don't see the point in why they should have independent legal representation. I've had this discussion with colleagues outside of the courtroom, and, you know, they don't see the point why, you know, somebody should have independent legal representation. But just because somebody's capacity isn't in question doesn't mean they shouldn't be asked what it is they want, what it is their will and preferences are, and that, you know, capacity is something we all value, our own capacity, our own ability to make our own decisions. It's not something that should be taken away lightly. And, you know, if it was us tomorrow, one of us tomorrow, I'm sure we'd all appreciate somebody would actually ask us, well, you know, what do we want? You know, so that's the biggest change, I think.
That's really interesting. Kind of a similar kind of question to you, Amanda, if you don't mind. It's kind of the evolution question, but also where are you seeing new, are you seeing a challenge? It's a sort of a challenges question as well. Where are the old challenges? Are any being resolved? And are you seeing new challenges emerging? So how is this evolving, we'd say, over the 18 months or so that you've been, you know, monitoring this from your perspective?
Yeah, so I think the again, I suppose probably the first few months everybody was sort of wandering around like a headless chicken. I think it would be fair to say that everybody was trying to figure it out as they were going along. So I think we definitely have gotten clearer in terms of the I suppose the processes that are needed and the emphasis that now needs to be put on things like the voice of the person in the court and having, you know, kind of good capacity statements completed sort of in a timely fashion, and be prepared to actually kind of stand up and sort of defend the opinion that we're giving and recognising the importance of that. I do think there continues to be challenges in relation to resourcing, and I know it has been previously mentioned, and I think it would be remiss to not mention it again today, in terms of the fact that, you know, to do this correctly takes time, and it takes energy, and it takes expertise, and I suppose what is unfair to everybody is to expect that that will be done in a consistent way, on top of what is already a very, very busy caseload for the vast majority of people involved across the entire spectrum. So that's not just healthcare, that's everybody.
And that resourcing issue, I don't know, Niall is still here, but the resourcing issue is a very big one, I think, for everybody, and I know for advocacy as well. Ultan, a similar question to you. And in particular, I wonder if you might address a little bit about the specified person, so the situations in which the specified person is used rather than a DMRO. Because again, for some of you, this may be very technical, so you might just explain, but these are really important issues in practice for a lot of people.
Yeah, and I think I'll do it in the context of, I mean, clearly we should absolutely not be going for a DMRO unless it's absolutely required and only for what is required. But similarly, I mean, the spirit of the Act and actually the requirement, the least intrusive, you know, involvement, you should not be going as a specified person unless that's absolutely required as well. And actually John Fairley, I think, spoke very well to this. He spoke last night about that innate Irish thing of helping people and the idea that, you know, your dad or mum is putting in a fair deal application and, you know what, I'll do it for them. They don't need to be bothered with that stuff. They're only going to get upset. But they're quite capable of doing it themselves. And while that is, you know, a nice feature, I think, generally of Irish people, that we help people, it's also kind of illegal at this stage. So, you know, we kind of need to stop it. In fact, it's not kind of, I think it just is illegal. So we need... we kind of need to stop that stuff. And like, it's a challenge. It's a challenge to all of us. Very innocently, 3 weeks before this legislation commenced last week, we signed off on our fair deal application form. It takes 3 weeks from the time we signed off until it just gets printed and distributed. And I actually thought ADMC was boxed off because we had put in the changes. Now, that was extraordinarily innocent of me, and it has taken up an unbelievable, it has been a privilege to work on it, actually, I have to say. And but there is this, I think there's a huge, people are challenged. We're all really challenged about trying to do the right thing, and it's balancing between having a piece of paper in a filing cabinet which confirms, because we're all regulated in terms of older persons and disability, and we're inspected. And that stuff in the filing cabinet gets you through the inspection. So there is this tendency maybe to say, well, DMRO covers us, or specified person covers us. We don't have to account for why we let the person do it. We have a legal document. So I would be concerned about that. I mean, you should only operate with the specified person when the applicant is unable to understand and give permission. Now, to be very clear, the applicant does not need to be able to sign the form. We actually have a statement of attestation that can be signed by people we recognise as nurses. We have a list of people who we're happy to accept that on. They don't need to be able to go to the bank. They need to be able to give permission. But I mean, 99% of the work can be done on their behalf. And it's a complex application form, we accept that. But we need to be very clear that we're not overstepping the mark and removing people's rights for them, even by thinking that we're doing the right thing.
Brilliant, thank you very much. I think we're running towards the end of the fireside chat, but we're going to be moving into the more general chat. Bibiana, I'm going to ask you just at the very end a very quick question, if you don't mind. Some of the themes, again, it's similar to this evolution point, some of the themes that if you were, and it's quite a challenging question, but some of the themes you're seeing emerge from your work with SAGE advocacy.
Yes, so we've done over 400 reports to circuit court, 21 circuit courts in the country, and I could endorse what you just said earlier. There are different experience across the country. What we see at the referral point, though, 75% of the referrals that come to us are with incomplete information. So it takes a lot of time for our advocates and information and support coordinators to gather all the information that is required for the advocate to properly and meaningfully engage with the relevant person in ascertaining their will and preference. We see in situations that sometimes no decision have to be made at the time. The application is made just in case or for future issues. We've seen on the most important problem and pressing problem from us is there's a very short turnaround. We are expected to turn around a very complex problem like this in 2-3 days. That's an impossible ask, and it's not fair to the relevant person who deserves the right time to meaningfully engage with that. We see that when we go to meet the relevant persons, in many cases they have not been made aware of the application at all, and sometimes, and I have a very brief example, it was an application about sale of the property, but the relevant person wasn't told that the husband had died. So even as we had to deliver that information ourselves 4 months after her husband's death. So there are vital information is not shared with the advocates or with the relevant persons. We have different level of engagement with solicitors. We know there was a lot of focus on our work in the last 18 months to demonstrate who we are, what we do, what the role of the advocate is, and why are we asked to be part of the process. We've developed information leaflets. They are available here on our website as well, just on the role of the advocate in the GMR applications and the role of the advocate in general. We know when attending court, it's very important that the older person is supported to attend in court. We've seen that they're expected to attend, but no arrangements are made, or nobody takes the responsibility to make that happen. Also, when attending virtually, there are issues around who is in the room when they are linking in virtually. There are issues around privacy. There are issues around undue influence. So that's all
really rich. Thank you very much, Bibiana. And that theme of time. This takes time. Well, that other theme of time. Actually, what we all need in life is an Elaine to carry around with us, and she'd ring a bell and we would be able to do everything. But actually, but that theme of time in a more general sense, as well as Elaine's impeccable timekeeping. Okay, thank you very much for that fireside chat. That was really excellent, and I think really rich insights there. But you're not allowed to move, because we are now moving to opening this to questions and answers. I still have lots of questions, so if you don't, I'm going to keep asking. And I know also the Caoimhe is going to, and I see her hand has already shot up. And do remember, anyone who has a question for Marie-Claire, either in the room or online, she can hear you, I think. I'm assuming. Yes, Caoimhe is nodding, but she will answer typing. This is because we're live streaming and we can't live stream out and live stream in at the same time. Caoimhe, over to you, please.
Okay, so it's a long question, so I'm going to try and truncate it. So essentially the question is asking, there's an inordinate amount of DMR applications that are to do with the ancillary state support. Is there any alternative process being considered to, given that it's just to do with the ancillary state support?
Ooh, Alton, I guess. Would that?
Well, I don't know, but I doubt it very much.
Yeah.
The legislation was changed. Our job is to implement the legislation. There is no other way. There is a single provision in law for a person to apply for ancillary state support when the applicant is unable to do that, and that's through a decision-making representation order, unless there's an enduring power of attorney in place. As to what happens otherwise, I mean, that's a much wider question.
Because in a sense it is a policy question, and therefore, but I think Anya has thoughts, so thanks very much, Alton. Anya's thoughts, but also I might turn to Judge O'Connor as well, just to ask, is that an actual accurate statement that cases are just about the ancillary support?
I think, sorry, Anya, do you want to?
Well, actually, you may just then verify what I'm about to say, which is that when the orders come to us, and we did do a bit of an exercise, Kate, my head of supervision, has been doing a review of the orders that have come our way. So it isn't true for the most part that what we're seeing is a direct replacement of the old care rep function with a DMR, because typically there are other orders, other functions, other decision-making authority that DMR is going to require. So the idea that it's a like for like, and why can't we just have a care rep still, because that's all that they do, just wouldn't actually be accurate. Perhaps care reps did more than they were strictly being authorised to do under the previous regime. I think that is something that, I don't know, Judge O'Connor might want to pick up on then.
And then we might go back to you, after Judge O'Connor, we might go back to you, Alton, just for your views on that aspect of things.
Yeah, Anya's absolutely right in relation to that. I mean, the question itself is just loaded when it says just. I mean, it's a nostalgia for the old care orders. And the reality is we're talking about human rights. We've changed the legislation. And apart from all of that, it's very rare that you would get just that type of order. There will always be something else in addition to that.
So, if I can as well, just in terms of, and I suppose just to be clear, I'm not a legal person, I'm an accountant, so clearly there's no point asking me legal policy questions. But in terms of what we're seeing in terms of fair deal, and we're seeing 70% of the DMROs coming through, and what we're seeing is that pretty much on a monthly basis, there are more orders, there are more issues being covered in the order, right? So clearly, I think there seems to be an understanding that there's actually quite a bit going on here. It's not just the fair deal application. The second thing I'll say to you is that we are seeing, over the number of years, we are seeing the people coming to Fair Deal have more complex financial products. So there's a standard person who is, might have a house, pension, 10 grand at the credit union. We're seeing people who have really complex financial products. And we're not talking about bank accounts, we're talking about complex financial products. And they need to be managed. Firstly, I suppose we need to make sure nobody's stealing them, because there is this sense of I'm entitled to it because it's going to be in my will. Secondly, that those funds may be used or may require to be used for paying for the client contribution and or other comforts or things that the person wants. So somebody needs to be able to encash those products. And thirdly, actually, some of those products that we're seeing, it's a very small percentage, but some of those products actually require active management. So these products might need to be sold at a time, they might need to be rolled over, they might need to be, there's work to be done with them. Now, there's a whole range of these products. As I said, we don't get a huge number of them, but we do get them. And it is about preserving the assets of the person. So I think the KRIP thing, to be honest, my non-legal sense is that ship has sailed over yonder horizon. It is just, there's a level of complexity. I think what's going to be really interesting, and I'll stop after this, but two things are going to happen. Firstly, the DSS will be monitoring at a period, and secondly, people will be back in for their period of review from the courts. I think it's going to be really, really interesting to see what's going to come out of that and what else will need to be added in. Because my strong sense is there will be more required rather than less.
Okay, thank you, Ultan. That's really helpful. And thank you all. That was, I think, a very comprehensive answer to that question. Caoimhe.
What is the role of the cognitive tests in the assessment? I presume the assessment of capacity. Some appear to be using memory tests that individuals are saying are not updated. Any clarification on both the role and acceptable tests?
So I think we probably could get some pretty quick answers. I'll go Sean and then Judge O'Connor. Well, actually, I'm not sure who I should go to first. But anyway, we'll go to Sean first and then Judge O'Connor.
There's no role for cognitive testing. So it simply is not the short.
So no role.
Replacement. It simply doesn't have it. They're part of what we do sometimes, but that's not the point. So there's no good waving MMSEs, MOCAs, or even neuropsychological test results. It's all about the functional test capacity based on specific decisions. And again, we don't want nostalgia for the days of MSEs being king. It's just not going to happen. Thank you.
Judge, I suspect you might agree.
Yeah, it's 100% agree with that. I don't think we even need to add to it. We're 18 months into it now at this stage, yeah.
Yep.
One more from Caoimhe and then we'll open to the floor.
Have the panel any advice for disability services on how best to record in evidence how decision-making is being supported and encouraged and capturing will and preference?
Oh, gosh. Amanda, would that suit you? Or do you think, Sean, which of you would prefer to go with that one?
It's just good clinical record keeping in general as to what you're discussing with people. And most of this isn't formal, it doesn't require capacity assessments. You're talking to your client or your patient or whatever you call it about what they want, about specific decisions, and you record it and you try and give effect to their will and preference. So I don't think it needs specific recording unless there's some reason that you need to in a particular context.
And I think sometimes if we're nervous about something or something is perceived to be new, we have a tendency to sort of look for a form, look for a series of boxes that we can tick, and that gives us a reassurance. But what it might give in terms of concrete yes or no, you lose out on the nuance of the conversation. And I think from the discussions earlier on and the contributions earlier on, for me it really stood out about it's the kind of the nuance, the conversation, it's kind of the context, it's all of those things that we lose if we start to just tick boxes or give kind of one word answers. So unfortunately it does take time, it probably takes up a lot of paper, but it is worth doing.
Brilliant. Viviana, and then actually I'm going to go to Judge O'Connor because I heard a murmur of Judge O'Connor down in the audience. I think they want your views too, Judge. But I'm going to go to Viviana first, if I may.
Very briefly, Todd, I think it's important that the assessment is carried out at a time that is best for the person to maximise their decision-making ability, and also to use the devices and assistive technology that's required to make sure that hearing and the batteries and the hearing aids and glasses and
Things which are
you
so
know,
simple in
things-
some ways and yet so
we take them
profoundly
for granted,
important.
but you'd be surprised the amount of times that the assessment happen after medication is administered and there are side effects or that. So there's a lot to consider.
That's really helpful. Judge, so your thoughts, and I suppose, I'm guessing the reason somebody said, ask Judge O'Connor down there, is they're also wondering what do you look for in terms of that?
Sure. Well, I mean, it has to be either done by a doctor, nurse, social worker, OTs, that's right, and a speech and language therapist and midwives even. But it's not done by a psychologist, it's not done by a lawyer. And one of the problems prior to the AC case that I did, or the AB case that I did, was that I used to get legal reports and they were almost like an assessment report, whereas I was actually wanting, what's the story with the assets? Is there any conflicts? Is there anybody under undue influence? That was the type of thing I was looking for. But, and obviously the lawyer needs to be conscious of the person's capacity, but the designated people are those, and that's what I'm looking for. You know, I've had reports with very serious amount of assets in with a psychologist, and with a medical report which was really done for a different purpose in the High Court. It wasn't done as a capacity report, and that's what I need is a proper capacity report.
Yeah.
Functional
So you're
capacity
looking
report.
for, in terms of capacity, a functional approach, but also that 360 vision.
Absolutely. Yeah.
Thank you. Any questions from the room? Yes? Oh gosh, lots of questions. I saw you first. I'm sorry, I don't know your name. And then Katie, and then I saw a hand back there. Super.
Just a quick question. Sorry, I'm Laura. I'm a social worker in
Hi,
Cork
Laura.
University Hospital. Just with when someone's leaving wardship, and the recommendation of the court is that they are appointed. That they have a decision-making assistant. What if they don't have anybody? So what if the committee was a solicitor? We don't have family members to appoint a DMA. We have people in the hospital coming in who are expressing an interest in getting a DMA, but there's not options for that. Is there any scope for a panel? I know there's an option for the co-decision maker. So.
That's great. Thank you very much. Somehow it's come to Anya, so excellent, Anya.
DMA being the lowest tier, and that would be a full discharge from wardship, because with the DMA you're still in charge of your own decision making. What a DMA does is quite light touch. CDMs might be more of a challenge where somebody has really nobody that they can call on to be that person in a pre-existing relationship of trust. And we do hear this a bit as well with people who are young people who have been in minor wardship, and then naturally there is no adult wardship and they might be better off with a CDM. So I mentioned in passing, probably very quickly this morning, a section of the Act called Section 41.3, which says that when a DMR, most likely a panel DMR, is appointed in default of a suitable co-decision maker being available, that DMR is obliged to give effect, I think it's decide jointly with the person as far as practicable. So they're not a co-decision maker, they are a DMR, but with that added requirement to decide jointly with, which is for us really to supervise. Bit of a challenge, but I think the court, the legislators conscientiously put that in. Panel? No. Well, and we can't set up what we're not authorised to set up. Maybe that's a second
But I think you
generation
point to
mistake.
something which is a real problem. And one of the things to remember that for some people, their whole lives may have been supported in their care services, and you can't appoint a co-decision maker who is working for the institution in which, if let's say you're resident there. So I think that's a really important point, Judge.
Just following up what Anya said there, about Section 41.3, we actually put that into the court order where somebody has been appointed from the panel, so that it's clear that the panel member is going to, even though they're not a co-decision maker, they have to abide by that.
That's very helpful. Amanda, did you want to come in on that? No. And I suppose actually it's no harm, maybe just spend, and I appreciate there are other questions, but maybe Anya, talk us through a small amount of the panel DMRs, and I know, because people, as in the existence of panel DMRs, and you get called on, and does that happen a lot? Or?
We have had, I think, 200 requests to nominate two, sometimes a few more, panel members. We're not apprised of the court application. This could be the first, most likely is the first that we know about it. So we have that established panel. About 50% of the membership are lawyers, and then we have social workers and other professions represented. They've all been individually selected, vetted, trained, and the training is ongoing. And we're currently doing a refresh of that panel. I'll be interviewing quite soon, and we're glad to see the interest in it. I think there was. And we engaged with the court. They wanted to see more people from a social work and a financial services background on that panel. But we operate that panel quite sort of dispassionately. When the request comes, we will nominate A and B because they're next to the top of the panel for that geographical area. If we get a particular panel member request looking for certain expertise, and that comes to us from the court, that's the court's assessment of it, not ours, then it might be A and F because we've skipped down to find somebody who's got different expertise. But that is a function of the panel member request that comes to us from the court.
Thank you very much. Katie, over to you, please.
Hi everyone, I'm Katie. I'm a social worker and I work predominantly in the acute services, but I've had the pleasure of working on the wards and going into court following the applications to completion. I suppose just an observation and then I have a question. I often stand forcefully with my good colleagues in acute saying why we're not going DMR. But sometimes what I have noticed is that when we have to go and initiate it, particularly for HSE, for DMR, for a loan, what I anticipated to be a loan ends up being a lot more decisions added in. And I just want to say that while I might go and we initiate assessment, a functional capacity assessment for a loan, what I end up often getting is a much wider ranging order. And I just want to flag that, you know, and now I know some judiciary are being practical and they're putting in more potential decisions, but that is happening. But then we're not going back to reassess the person on those other decisions that get included. I just want to say that I'm noticing that pattern. And the second thing, because I'm the HSE and we like value for money, and I have a lot of relevant persons with substantial assets, I wanted to get maybe Judge O'Connor and maybe Amanda's opinion on costs, particularly for the HSE-based applications where we're initiating. I suppose I'm looking for clarity and still waiting what's happening, because some of the judiciary are turning to me, smiling down, well, do you want your costs back? And some are just automatically making declarations. And I'm wondering what is happening, particularly with you, Judge O'Connor, with costs.
Yes, a difficult question. In relation,
And obviously you can only speak about your own.
oh, absolutely, yeah. In relation to costs, it depends really on the application, and it depends on the amount of assets somebody has in relation to it. The DSS are not going to get involved in that. We're not going to. The idea of drawing up a large bill of costs and sending it into the judge to give is probably not going to work. Rarely do the HSE actually ask for costs.
I know, but the judge looks down, smiling, going, well, what you want?
The answer.
I don't think you'd have got that from me. But,
No, I haven't.
But I mean, if there is an application for costs and there is a reasonable amount of assets, then we can look at it. I mean, it's case specific rather than trying to make a general comment in relation to it. I am somewhat parsimonious in relation to costs. I'm conscious of what the Legal Aid Board pay in relation to costs, and usually it's quite often in relation to the applicants. One of the reasons why we have 40% of lay litigants is because they can't afford the applications.
Thanks, Judge. Joanne, actually, do you have any thoughts around that? I'm just thinking again to get an outside Dublin
in relation to the
perspective.
costs, and I suppose to answer Katie's question in relation to the applications, what Judge O'Connor said is correct. It depends on the assets of the relevant person. But I mean, there have been HSE applications that I've been involved in where, unfortunately, family members are not on the scene for whatever reason, and the HSE have had to bring the application. The relevant person has substantial assets. And in those cases, I would always kind of say myself to the solicitor, look, are we going to seek an order for costs here? Like, there's no reality to seeking an order for costs for someone who's on an old age pension and doesn't have anything else. But if the relevant person has money, the order for costs are being made, generally speaking, in favour of the HSE. Now, I should say measured costs. It's not just what are your costs and we'll give you an order. So they're measured appropriately, but still there is some recoup there. I think it's a matter, I suppose, really for the HSE to decide, are they seeking their costs? But I think it very much depends on whether or not there's funds there.
That's really helpful, Joanne. Amanda, did you want to say anything on that?
No, I think again,
Excellent. So, yeah,
it
sorry.
does have to be a kind of a local decision made within the regions in terms of kind of the approach that is going to be taken. I don't think it's ever going to be appropriate to sort of make a blanket decision that we're always going to do that. Yeah.
Super. I know there was a hand back there, lady there in, I think it's a green top, and I saw another hand here in a different colour green top, I think. And then I also see Elaine beginning to shift nervously in her seat. So I'm not sure we'll have many after this, but thank you.
I know that up until 26th of April 23, there were still opening applications to enter wardship. I'm wondering how many active applications to enter wardship is now, and how are they closing, and if they are closed, how are they closed?
Great question, and that is a really good point, which is, as I think you've said on occasion, perhaps Anya, that we've had more entrants into wardship than exits from wardship since the...
Is Mary Claire still in the ether somewhere? Because I can estimate numbers, but based on what we heard last week, something like 200 for all of 2023 and possibly another 40 admissions to wardship this year. Never quote me on that because I don't own the stats.
So if you don't mind holding, what we're doing is we're hoping Mary Claire will come back and we can come back with a precise question. But in terms of, we'd say, the tenor of your question, which is that we have had people continuing to be admitted to wardship. And in case people are wondering how that is, that's because if the application process had commenced before the Act commenced, it can then continue. So that's just to explain why that happens. Hopefully we can go back with a more precise answer to you on that, but certainly to respect the tenor of that question, you're absolutely right in drawing attention to that. Woman there in the other green, and the Mayo colours actually, Judge O'Connor and I are very approving of you in that respect.
I hope I have, I'm with the level of expertise both on the panel and on the floor, I hope I'm not picking up the wrong end of the stick. It's in relation to the enduring power of attorneys, the old ones and the new ones. Specifically, I suppose my understanding is the old enduring power of attorney gives the attorney the right to place somebody in a nursing home, not necessarily against their will. I understand the need in her jurisdiction, but they can make a decision about their placement, whereas the new enduring power of attorney doesn't necessarily give the same. And I suppose my difficulty, is in relation to the will and preference and the emphasis on the will and preference. The old legislation doesn't seem to take that into consideration to the same degree. And yeah, sorry.
That's an excellent question, and I'm going to turn to the man who is well able to answer it.
I know accommodation is listed as one of the decisions, but this is not a power for supporters to detain somebody or deprive them of liberty. So, we've been through this with a number of cases.
And you mean under the 96 Act as well?
Under 96 or under the latest, none of them gives the power of deprivation of liberty. And it was wardship, it's now in here in jurisdiction of the High Court, but a totally different matter. So you can make accommodation decisions, you can negotiate rent, you can do all kinds of things around it. But what you can't do is send somebody to a nursing home because they have an attorney or even a DMR with that power. So that is High Court, a different territory. It's really important that we don't try and sneak detention matters under Part 5 applications, or indeed that attorneys don't exceed their scope of what they're allowed to do. So no detention powers for supporters under ADM. Thank you.
And Sean, do you think that perhaps there might be some misunderstandings out in the system?
Oh, I think there is. And we've come across it. We were in, I don't know if Anya Hines has left, but we ended up in the High Court on such a case fairly recently. Again, where there was an attorney, a registered attorney, looking to use those powers to detain somebody, and they didn't have them, and the President explained that very clearly to them. Thank you.
Sorry, just it's in relation to the old enduring power of attorney. Yep. The advice that I was given at the time from a number of organisations that are represented here was that they could go against the wishes of the person, which didn't sit comfortably with me. And I suppose I checked it out with a number of the organisations that are represented, and I was told the old enduring power of attorney does. We had a patient that did change their mind, but it was initially very resistant to long-term care, and the enduring power of attorney was very much.
I don't think that's justified. You know, the old one, the new one, none of them get powers to detain.
Perfect.
But I think it's understandable. Sorry, I'll stop. Apologies back there. The dreaded bell has rung. So I am going to thank our panel. Thank you very much for that excellent fireside chat.
So I just want to do some concluding remarks, if we can. Thank you. So I think just to, first of all, to say like a big round of applause to all our speakers, our experts, our contributors, to everyone who helped today. And again, as I said yesterday, like, you know, there's always an intention around these days at like what next and what are the kind of takeaways. So I think, you know, just some kind of high level takeaways are the profound impact of story. I think you can all agree that the stories of Kaylee, Sarah Jane, PJ, Darren, Bart, Breege and William, you know, they were profound, they were really important, they really bring us back to the reason why we're here. And I think just again, big round of applause for their sharing their story. I'm eternally grateful for that. I think allied to that and from those stories, you can see that support is absolutely critical. And I think that is a gap. You know, in terms of that, if you don't have that support, and we saw that in your story, Sarah Jane, that you have to have the support to be able to go on to do so. So that's something that, you know, I think that's a gap, and that's something that we need to take away and look at that kind of more concertedly. Yeah. Great. We'll chat to you afterwards, okay? And then the other, I think, very big thing that both Susie and Jackie and Emer said earlier on, which is we cannot take rights for granted. I mean, we live in a world now where we know rights are getting eroded everywhere. So, and also people from the floor also said this as well. So, you know, ageism is widespread, ableism is widespread, and intolerance of indifference is widespread. So the gains that you make, well, you can easily lose. So we, you know, not to take any of this for granted, because that could get eroded again. I mean, critical in all of this is the voice, you know, and I think this is such a different place than where we were in 2019. And it was tremendous to hear the stories from the court yesterday and about how that's just, you know, that is the way it is, and also from everybody today about what's actually the point here, you know. So I think just to really commend and to say like how important it is to hear that, and how important it is to kind of have that noted. The issue of planning ahead, the importance of planning ahead. We heard from Fiona, we heard from Patricia, we heard from Emer, you know, about, and Anya, in terms of like all of you today, if there's one thing you can do, try and make your EPA, try and make your wishes known, do your advance, even do a cursory advance healthcare directive, because we, as I said yesterday, in our office know that by not planning ahead, it has a very significant impact on your life. So do kind of take that away. Jackie mentioned the whole issue of, you know, the rebalancing of risks and rights. I think that's something that we really, really need to kind of look at in much more detail. In terms of things for our officials, I don't know if they're still with us, but anyway, this will be recorded online, so you'll hear it afterwards, even if you're not in the room. Niall and others. The whole issue of advocacy, I think we've seen that, you know, the importance of advocacy all the way throughout. But the other kind of warning I would say around advocacy is we still have nearly 2,000 people to leave wardship who will also need advocacy support. We also have all of those hundreds of people that are going into inherent jurisdiction. They also need advocacy. And then all of the thousands of other people who don't have advocates. So, you know, it's not a cursory thing, it's a real fact. And I think there is an absolute need for a strategy on advocacy at government level across all of the levels. The legal right to be represented, I mean, I think that was really great to hear that, and we've heard a lot from our colleagues from the Legal Aid Board. I know we still have our Legal Aid Board colleagues here, but the legal aid practitioners that are working on the ground, I think it's very Darren's story about, you know, being supported by the legal aid practitioner in Dublin, I think was great to hear. Mary Claire's reassertion that a person has a legal right to leave wardship. I think that's a really important message to take away, and also that you as practitioners, whether you're working in health and social care, have a job to do to support people on that journey. And I think we learned some very helpful stuff from Selena on practical things that can be done. Okay, so in terms of just thank yous that I want to say, thank you to our speakers again for doing such a sterling job. Thank you to our colleagues in UCC, to our colleagues in the DSS, to you, the audience, for such participation, to the audience that's been online. We've been flat out writing, answering questions all day long, and I think that's been really helpful in terms of being able to have lots of people who couldn't travel here today, who weren't able to travel or who weren't facilitated to travel. I think it's great to have this. But the other thing about this is recorded. It's going to be available to people. You can share it with people that weren't able to make it. And for those that are educators, you can share it again and maybe segment parts of it as well. I think big round of applause to the hotel. They did a fabulous job, and they've done, in terms of the whole package, really delighted. To our IT team and our tech team down in the corner, to Tom, Bernard and Cian, fabulous job. We can't do this without them. You can't do live streaming without having a tech team like the dream team down below. To our timekeeper, Elaine, and our bell ringer, Katie, great work. So I think sorry, Elaine, I got 1 minute left. So just to say a couple of things. Any CPD requests, you send them online to adm@hse.ie and we'll deal with that. The recording and the papers will be available. We'll let you know. All delegates will be told about that. I want to do kind of a shout out to, so there will be, we mentioned the online training on the functional assessment of capacity. So we've had a lot of questions about that. When is it out? Is it out now? It's not out now. It'll be out in a couple of weeks because we had to get stuff ready for the conference. So give us a couple of weeks and then it'll be ready. And then there will be in-person training in the new year. It'll be phased out, but we'll communicate that with you as well. One last kind of shout out that I want to say as well is to our HSE mentors and mentees and ADM leads. They are doing absolute sterling work around the country, and some of them alone with very little backup as well. So just to say thank you so much for doing that. I know a lot of them are online, so just really to call that out. So it remains to say just thank you all again. Safe journey home, and Gormila Mai Good Slán.